Let's jump right into this deep dive. Recent headlines have been buzzing quite a bit about a significant development in the long-running border situation between Thailand and Cambodia.
That's right. We had a meeting of the Joint Boundary Commission,
Mhm.
the JBC, happening in Phnom Penh.
Right.
Now, these meetings are usually focused on the really technical, kind of detailed work of demarcating the border.
Mm.
But this time, something else entirely stole the show.
It really did. On the second day of that meeting, Cambodia made, a pretty dramatic announcement. They were filing a submission with the International Court of Justice, the ICJ,
Yep.
specifically about 4 disputed border areas.
And that news, understandably, it just dominated everything.
Totally.
For this deep dive, we've pulled together news reports covering that JBC meeting and Cambodia's big announcement, official statements from the Thai government clarifying their stance, and also some really helpful legal analysis looking at what actually happens at the ICJ when one country brings a case, but the other says, hold on, I don't accept this court's jurisdiction.
Right. So our mission today is basically to unpack what actually went down at the JBC.
Yeah.
Understand why Cambodia made this move to the ICJ right now, sort of sort out the confusing back and forth about which maps are supposedly in play,
The map issue.
and then really dig into the complex legal and political reality of trying to resolve these kinds of disputes on the international stage.
So yeah, get comfortable. There's a lot here that goes well beyond the initial headlines.
Yeah.
And we're going to guide you through it.
Okay, let's unpack the sequence of events then. The 6th JBC meeting between Thailand and Cambodia was scheduled for June 14th and 15th in Phnom Penh.
Right.
As you mentioned, the point of these meetings is usually the technical demarcation of the border, talking about field surveys, agreeing on methods, reviewing past work.
It's the painstaking process, really, marking out that roughly 800-kilometer line.
Exactly. It's meant to be methodical, working through the agreed-upon procedures to, physically place markers on the ground where possible.
But then, on the morning of June 15th, boom.
Yeah.
Cambodia announced they were taking the issue of 4 specific disputed border areas to the International Court of Justice.
And that announcement completely shifted the focus.
Oh, totally. News cycles immediately pivoted from the, dry, technical JBC talks to this major legal development.
And here's where it gets really interesting about what happened inside the JBC meeting after that announcement.
Okay.
On that same second day, Cambodia actually tried to get their ICJ submission officially noted in the joint meeting record. Essentially saying, hey, this ICJ thing we just announced, let's put it in the minutes here.
And Thailand refused.
Flat out refused.
The reports indicate this was a very deliberate move.
Yeah.
It's incredibly sensitive because acknowledging or even simply noting the ICJ matter within the JBC context could potentially be interpreted as somehow accepting the court's jurisdiction over these specific disputed areas.
Which, as we know from the history, particularly that painful 1962 Temple of Privahir case.
Where Thailand lost territory.
Exactly. Avoiding anything that could even hint at accepting jurisdiction in new areas is, well, it's a core defensive posture for Thailand.
So with Thailand declining to include it in the joint record, Cambodia is now proceeding with the ICJ submission unilaterally.
Just going ahead on their own.
Yep.
Cool.
And Thailand is officially maintaining its long-standing stance.
Yeah.
We do not accept the ICJ's jurisdiction over these particular areas.
Okay. But despite this major announcement overshadowing things, Cambodia's statements did detail the technical JBC agenda items that were still discussed, right?
They did. They talked about reviewing previous reports, discussing amendments to a 2003 Memorandum of Understanding regarding orthophoto map production,
Okay, technical stuff.
approving joint field survey teams, and going over measurement methods in a specific area known as Sector 6, standard JBC fare.
But there was a crucial caveat in Cambodia's statement.
Yes, this is important. They said the 4 disputed areas they're taking to the ICJ will no longer be subjects of discussion or dispute resolution within the JBC framework.
Wow, okay, so they're drawing a line.
A very clear one. They're signaling that for these 4 specific points, the JBC isn't the place to resolve them anymore. They've moved the intended arena to the court.
So the technical JBC talks on other, maybe less contentious points will continue.
Seems so. Thailand is even set to host the next special session in September.
Okay.
But for those 4 flashpoints, Cambodia has clearly decided to pursue a different path.
Okay, so we've seen what happened at the meeting, Cambodia's big announcement, Thailand's refusal to put it in the record.
Right.
But how did the rest of the world hear about it? The way information came out from each side, well, It tells its own story, doesn't it? Highlights a difference in communication strategy.
You can definitely see it in the reports covering the events. Cambodia was incredibly fast and detailed in their public messaging.
Very quick off the mark.
Yeah, detailed statements came from a minister-level official almost immediately after the meeting wrapped up. They were active on social media, too.
The Prime Minister posting about the ICJ submission package, right?
Exactly. They got their detailed narrative out, like, rapidly.
In contrast, the initial communication from Thailand seemed, well, slower and maybe more cautious.
That's how it appeared. The head of the Thai delegation returned to Bangkok, and the Ministry of Foreign Affairs' first public statement was brief and quite general.
Just emphasizing the importance of the JBC and the overall border cooperation framework, the JBC, GBC, RBC tiers.
Right. And detailed information was promised later, specifically tomorrow.
And the consequence of that delay, I mean, it's noted in the analysis we looked at, seems pretty clear in the media coverage.
Yeah, Cambodia's detailed version of events and their claims were the first ones widely reported.
Meaning they potentially shaped the initial public perception, the narrative, before Thailand's full, detailed response was even available.
And in the age of instant information and social media, being quick to frame the story can be a real strategic advantage.
Sure.
A delay, even a short one, can mean you're already playing catch-up in the public discourse.
All right, let's dive into another core point of contention that popped up almost immediately after the meeting, this issue of the maps.
Yes, the maps. Always crucial in border talks.
Cambodia's post-meeting press conference included a really specific claim. They said Thailand had agreed during the JBC meeting to use the 1,200,000 map for the demarcation process.
This is where a lot of confusion really started, I think.
Yeah.
That 1,200,000 map is historically significant, sure. It's linked to the 1904 and 1907 Franco-Siamese treaties, and it's mentioned in the 2000 MOU.
Right.
But the claim that Thailand agreed to use that specific map scale now, well, it seemed to contradict previous Thai preferences or approaches.
Which often favored the more detailed 1,50,000 map, didn't they?
Exactly. So Thailand's official response was swift and direct.
What did they say?
Statements from the Ministry of Foreign Affairs, and apparently backed up by the Pheu Thai Party, explicitly refuted Cambodia's claim.
So a flat denial.
A very clear one. They stated clearly that the 1,200,000 map was not discussed at the JBC meeting, nor was the ICJ issue discussed there.
So we have two directly conflicting accounts of what was or wasn't agreed upon or discussed at the meeting regarding this map.
Precisely. And understanding why the map scale is such a critical flashpoint is really key here.
Okay.
Drawing on the perspective offered by Dr. Prowas Fwedi in one of the articles gives some helpful context.
So why does the map scale matter so much in border talks? I mean, is 1,200,000 really that different from 1,50,000 on the ground?
That's where the technical detail meets the real-world implications. Think of it like this.
Yeah.
On a 1,200,000 map, a line drawn with, say, a pen tip, maybe 0.5 millimeter wide,
Okay.
actually represents 60 meters on the ground.
60 meters. Wow.
Yeah, that's a huge margin when you're talking about defining a precise borderline. A 1,50,000 abit is significantly more precise. That same pen tip represents only 15 meters.
Okay. 60 meters versus 15 meters for the width of the line itself. That is a massive difference, especially in potentially disputed territory.
Exactly. And the 1,200,000 map itself is seen by some as problematic for other reasons, too.
Like what?
Well, it's over 100 years old, for starters, based on less precise survey methods than we have today.
Right. Pre-GPS, pre-satellite imagery.
Totally. And Dr. Pawas's view, as presented in the source, describes it as a map produced by France during the colonial era,
Okay.
and perceived by some, particularly on the Thai side perhaps, as a tool used to delineate borders in a way that facilitated the acquisition of territory by the colonial power.
So the concern is that using this less precise, historically controversial 1,200,000 map for modern demarcation is inherently risky for Thailand.
That's the argument.
Those wider lines or less accurate placements could be interpreted to include territory that Thailand considers unequivocally its own.
Precisely. The argument from Dr. Prewas's perspective, as presented, is that modern border demarcation, which involves physically placing markers,
Right, the actual posts in the ground.
should rely on the most accurate methods available today. Detailed maps based on satellite imagery, GPS coordinates, clear natural features like watershed lines.
Things that are much harder to dispute based on the imprecision of an old map.
Exactly.
Yeah.
So based on that viewpoint, Thailand's position, as articulated in their refutation of Cambodia's claim, is that they should not and did not agree to use that old 1,200,000 map for current demarcation work.
Okay, so given all this, the JBC meeting, the dramatic ICJ announcement, the conflicting claims about the maps, the big question for those four disputed points is, what does Cambodia's move to the ICJ actually mean legally?
Right.
Especially since Thailand is clearly saying no thank you to that court's jurisdiction for this matter.
That would seem like a dead end, wouldn't it?
Yeah, logically.
Hmm.
If one country simply doesn't consent to being sued in a particular court, surely the case can't proceed.
That would make sense in many domestic legal systems. But international law and the ICJ, well, they have their complexities.
Oh.
Based on the legal analysis we examined, it's not quite that simple because of how the court handles jurisdiction disputes.
Okay, tell us more. How does that work?
Well, the fundamental principle remains true. The ICJ's power to hear a case ultimately depends on the consent of the states involved.
Consent is key.
Absolutely. And consent is usually given in advance, maybe through a treaty clause or a general declaration accepting the court's compulsory jurisdiction for all disputes, or sometimes a specific agreement drawn up just for that one case.
But if, like Thailand is asserting here, the respondent state hasn't given consent through those usual routes, what happens then?
The case isn't automatically thrown out. The court actually enters a specific phase to address this exact issue. It's called the preliminary objection stage.
Ah, the preliminary objection. So they tackle the jurisdiction question first.
Exactly. The court presses pause on any examination of the merits, the question of who is right or wrong about the border itself.
Got it.
Its sole focus in this preliminary phase is to determine if it has jurisdiction under international law. It looks at any relevant treaties, past agreements, the conduct of the states, other legal grounds presented by both sides.
So historical context, like the 1962 Pre-Avinhair ruling or maybe treaty terms, could come into play here.
Potentially, yes. The court considers all relevant legal arguments concerning its jurisdiction.
Okay, so what are the possible outcomes of this preliminary objection phase?
Two main possibilities. Outcome A. The court rules that it does have jurisdiction.
Okay.
If this happens, the case then moves forward to the merits phase. The court will examine the evidence and arguments about the border dispute itself.
And what if Thailand still refuses to participate?
And here's a crucial point from the analysis. Even if the respondent state, like Thailand in this hypothetical scenario, then refuses to participate any further, the court can still hear the case.
Really?
Yes. It can proceed based on the evidence presented by the applicant state, which is Cambodia here, and international law, and it can issue a binding judgment.
Wow. So you can't just walk away and prevent a ruling if the court decides it has jurisdiction. That's significant.
It is. Now, outcome B is the opposite.
Okay.
The court rules that it lacks jurisdiction. In this case, the case is dismissed entirely. The ICJ will not make any ruling on the merits of the border dispute. The matter ends, at least as far as the ICJ is concerned.
Right. Now, the legal analysis also brought up an interesting concept called forum prorogatum. What's that about?
Yes, forum prorogatum. It's a bit more unusual, but it's another way jurisdiction could potentially be established. It happens if a state gives its consent after the case has already been filed against it.
So consent after the fact.
Kind of. Under the ICJ's rules, specifically Rule 385, if a case is filed hoping for this future consent, forum prorogatum, the court's registry doesn't officially docket or activate the case.
It just sits there.
It essentially waits until the respondent state explicitly consents later on.
So like the court clerk puts the case in a pending pile until the other side says, okay, I'll show up.
That's a pretty good analogy, yeah. The case is filed, but it's not actively before the court until that consent is given.
And how can that consent be given? Does it have to be written?
It can be explicit, like a clear written statement saying we consent. Or, potentially, it could be implicit, demonstrated by a state's behavior in the proceedings.
How would implicit consent work? Like if they accidentally started arguing the main points of the case before clearly saying they object to jurisdiction.
That's the kind of situation where it might arise. Past cases have looked at whether a state's actions within the court process, like arguing the merits without clearly reserving their jurisdictional objection first, could be interpreted as implied consent.
But is that easy to prove?
No, and the analysis emphasizes this. The ICJ applies a very high standard for interpreting implicit consent.
What's the standard?
It has to be a clear and unequivocal indication of consent, and a voluntary and indisputable acceptance. Simply showing up and participating in the process, only to argue that the court lacks jurisdiction, is not considered implicit consent.
Yeah.
The court understands a state needs to appear to challenge jurisdiction.
So, while forum prerogatum is a legal mechanism that exists, and it has apparently been used successfully sometime.
Yeah, the analysis mentioned Djibouti versus France as an example where France explicitly consented later.
It sounds like it's relatively rare and probably legally challenging to establish, especially when a state is actively and clearly opposing the court's jurisdiction right from the start, like Thailand seems to be doing here.
That seems to be the takeaway, yes. It's not a common route and requires that clear acceptance.
So, bottom line,
Yep.
even with Thailand's very clear refusal of jurisdiction right now,
Right.
the ICJ process initiated by Cambodia for these 4 points involves a formal legal phase where the court itself will decide the question of its own jurisdiction.
Exactly. It'll be based on international law and the history of agreements and interactions between the two states. It's not a simple no, and that's the end of it, from a procedural perspective at the ICJ.
Okay, so let's follow that thread. Let's consider the scenario where the ICJ does find it has jurisdiction, and eventually, after looking at the merits, it issues a ruling.
Okay, hypothetically.
That brings us to the final and maybe the biggest hurdle, enforcement. What happens if the court rules in favor of one side? How does that ruling actually get put into practice on the ground?
Yeah, this is where the practical realities of international politics really bite.
Because there isn't a global police force, right?
Exactly. Unlike our domestic legal systems, there isn't a direct world police force or a sheriff that can just show up and enforce an ICJ judgment.
So how does it work then?
As the analysis explains, enforcement primarily relies on a political body,
Mm-hmm.
the United Nations Security Council, the UNSC.
Ah, the Security Council. So the UNSC can make a country comply.
Well, they have the authority under the UN Charter to try. The Charter gives the Security Council the power to adopt resolutions or maybe decide on measures aimed at compelling a state to comply with an ICJ judgment if that state is refusing to do so.
Okay, but isn't there a really significant catch there? Something about veto power.
That is the major obstacle, and it's absolutely crucial to understand. The 5 permanent members of the UNSC, that's China, France, Russia, the United Kingdom, and the United States, each hold veto power.
And what does that mean in this context, if the ICJ makes a ruling?
It means that if any one of those 5 permanent members decides to support the country that is supposed to comply with the ICJ judgment.
Maybe because of their own political or economic interests.
Exactly. If they support the non-complying state, they can use their veto power to block any resolution or measure proposed in the Security Council aimed at enforcing that ICJ ruling.
So one P5 country says no, and enforcement action stops.
That's the power of the veto. It means ultimately even a ruling from the highest international court, based on complex legal arguments and evidence,
Can be effectively impossible to enforce if it goes against the political will of one of the most powerful nations in the world.
precisely. They can simply say no in the Security Council, and that's that for UNSC-led enforcement. It really highlights the inherent tension in international law.
How so?
It operates in a system of sovereign states where political power dynamics and national interests can, and often do, significantly impact the practical application and enforcement of legal judgments, even from the ICJ.
Okay, let's zoom back out now and try to bring all these threads together for you, the listener.
Yeah, it's been a lot to cover.
We've taken a deep dive into the layers of this recent situation. A JBC meeting focused on technical border work that was completely upended by Cambodia's sudden announcement about taking 4 disputed points to the ICJ.
We looked at the conflicting claims about which map scale matters and why that whole 1,200,000 versus 1,50,000 debate.
Right, and the difference in communication strategies that played out publicly, with Cambodia getting their story out fast.
Then we explored the intricate legal steps involved at the ICJ, even when jurisdiction is disputed. The preliminary objection phase, the idea of forum probatum.
And finally, the fundamental challenge of enforcing international judgments because of the political reality of the UN Security Council veto.
So summarizing the key points, Cambodia is pushing these 4 specific disputed areas into the international legal arena, explicitly stating they're now outside the scope of JBC discussions.
Meanwhile, Thailand officially refutes Cambodia's claim about agreeing to use the less precise 1,200,000 map for current demarcation work.
And Thailand steadfastly maintains its non-acceptance of the ICJ's jurisdiction over these particular points.
However, as we discussed, the ICJ process isn't simply stopped by an objection. It includes that formal jurisdictional review phase where the court itself will analyze the legal basis for hearing the case.
That happens independent of the immediate consent or objection at the time of filing.
And critically, Even if the court does ultimately rule on the merits, the enforcement of that judgment faces those significant practical and political hurdles within the UN Security Council.
Where the veto power of a permanent member can potentially block any action to compel compliance.
These events really do lay bare the multi-layered nature of international relations and especially border disputes, don't they?
Absolutely. It involves deep history, technical challenges of drawing lines on maps and on the ground, complex legal arguments debated in the world's highest court.
Strategic diplomatic communication playing out in real time in the media.
And ultimately, that hard reality that international law operates within a system where sovereign power and political interests, backed by the ability to veto enforcement, play a really crucial role.
And this brings us to a final thought for you to ponder as you process all this.
Yeah, something to chew on. Given that the enforcement of rulings from the highest international court can appear to be so heavily dependent on the political will, and specifically the veto power, of major nations in the Security Council.
Does the situation reveal an inherent limitation, maybe even a kind of ceiling, to the true effectiveness of international courts in resolving the most high-stakes disputes between powerful or politically connected states?
Or is this simply the current structure of the international system we live in? And perhaps other mechanisms like continued bilateral talks on less contentious areas, maybe?
Or even strategic legal thinking, like Dr. Proass's suggestion mentioned in one source about potentially filing a countersuit regarding other areas like COCOM.
Right, exploring other avenues.
Do these represent the more realistic, albeit perhaps slower, paths to peaceful resolution in this complex geopolitical environment?
It's a fascinating question, and honestly, there are no easy answers.
We hope this deep dive has given you a clearer picture of the many dimensions of this unfolding situation.
We certainly hope so. We appreciate you joining us.
Thank you for going on this deep dive with us today, and that's the deep dive.